pledge to the flag. I pledge allegiance
to the flag
of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. We've had a chance to read the minutes. Have you read the minutes? Yes. Okay.
There is the one change that needs to be.
Yeah, there's a change in the earlier one, no, the later one, the April,
19.
no, in the early one, the February
Oh,
one.
the February.
Dave Lovell didn't call the meeting to order, I did. So, given that, any other corrections or additions? If none, we can vote on both of them together. Anyone want to?
So moved.
So move to approve the minutes as corrected. All those
We
in
have a
favor?
second.
Aye. Oh, second. All those in favor? Aye.
Aye.
Okay, the minutes are approved. Okay, everyone who's going to testify in this matter needs to rise and be sworn in.
Do you solemnly swear or affirm that the testimony you're about to give is the truth, and only the truth, so help you God?
I do.
Thank you. Sorry for the motion.
Sir, are you going to testify in the matter?
No, I did not
He's
plan
an
on having
attorney.
to testify.
He's an attorney.
I'm an attorney.
And the other man's not going to.
I do not plan on having Mr. Tate testify.
Okay. All right, well, this is case number 17-003374, an alleged violation of 50003 building setback requirements. Mr. Rose, you're going to present.
Yes, sir.
Would you proceed?
Everybody see okay? Do you need that one turned more? Are you good?
I'm good.
Should be good. Okay. All right, good evening, everyone. For the record, my name is Kurt Rose, Officer for Code Enforcement, Walton County. I'm submitting this final report and PowerPoint presentation as evidence. This is Code Enforcement Case 2017-3374. Mr. Jeffrey and Terry Tate at 106 Beach Drive East. On June 19, 2017, we received a complaint that the pool pavers extended into the setbacks at 106 Beach Drive East, which is located in the unincorporated areas of Walton County. On June 19, 2017, I conducted an inspection of the property and found it in violation of Ordinance 97-28 of Walton County Land Development Code 5.00.03 building setback requirements. On screen now is the property appraiser's information, green card. The notice of hearing was returned unclaimed by the address. Uh, 5.00.03 building setback requirements are as follows. The important one on this one to make note of is number 7C for nonconformance, where it states that all nonconforming undeveloped residential lots platted or unplatted prior to June of 1975 may be developed with a minimum 5-foot setback. This particular property was platted prior to 1975. However, there is a director's determination that was done in February of 2016 for this particular subdivision, and it talks about non-conforming. I'll just read it to you. It says the Walton County 1975 subdivision regulation provided for a minimum lot size of 10,000 square feet. A non-conforming residential lot was as referenced in the Walton County Land Development Code 5.00.03C is determined to be a residential lot, platted or unplatted prior to June 1975 and having a gross area of less than 10,000 square feet. Therefore, to allow a 5-foot minimum setback side consistent with the LDC 5.00.03C. The lot must be a lot of record prior to June of 1975, and must have a gross area of less than 10,000 square feet. In this narrow circumstance, a 5-foot side setback may be allowed without the requirement of a variance approved by the Walton County Board of County Adjustments. This particular lot does not qualify for that because it exceeds 10,000 square feet. On July 10th, 2017, I spoke to Mr. Tate by phone. He had stated his home was platted prior to 1975 and that he should be allowed to have the 5-foot setbacks. He asked for time to speak with the planning department in regards to this, as it should have been caught during the planning stage. He also stated he lived out of state and it was a problem getting back and forth. He said he would be in town mid-August to go through this process. On September 7th, 2017, I spoke to Mr. Tate again. He stated his contractor, Andy Bino, was working with Walton County Planning Department for a variance request to allow the pavers to stay in the setbacks. In October 2017, Mr. Tate himself came into the planning office and we again discussed the lot being platted prior to 1975 and only requiring a 5-foot setbacks. At that time, he requested to speak to Matt Carpenter, the planning director, to go over this. On November 20th, 2017, I received the confirming information from the planning director that a conversation had occurred between himself and the property owner, and that determination was made that the lot did not qualify for the 5-foot setbacks. And the reasoning was, as I had stated earlier. On December 11th, a notice of violation was sent certified mail to the property owner of record, according to the property appraiser's website. On February 20th, I received an email from a Melissa Ward with Dunlap and Shipman stating that they would be representing Mr. Tate in an attempt to get a variance to allow the pavers to stay. On March 19th of 2018, I received an email from Melissa Ward stating they would no longer pursue a variance and that Mr. Tate is requesting to move forward with the Code Enforcement Board hearing. On April 30th, the notice of hearing was sent out certified mail. It was returned unclaimed. On May 2nd, 2018, an email with attorney Mike Henry contained a copy of the notice of hearing and a confirmation of this hearing date. The survey here is the final survey that was, or the foundation survey that was done for the pool. Oops, let me back up. As you can see, when they had this home built, which based on the date here was in 2016, it actually says 12/14/2016 in the date in the red ink stamp. Everything on this, it has a 10-foot side setback on the flat side of the house. Around the pool is 10-foot side setbacks. There's a 20-foot setback at the front of the house, which is where Beach Road is. And then there's a 15-foot building setback at the rear. That's what was determined and what was allowed from the planning department at the time of permitting. For your information, these are the director's determinations that pertain to this. 2016-02 refers to pool decks, pavers, and setbacks. And it states that pool decks and their associating, or pools and their associating decks are considered structures and to be used and not be allowed in the setbacks. And then the director's determination 2016-04 is the one I read to you, which this lot exceeds 10,000 minimum square feet. So it is not a non-conforming structure, or non-conforming lot, sorry. The photo here shows the fence. The black fence is the property line. They had their fence placed right on the property line. There is approximately 2 feet worth of gravel, and then the pool deck pavers start. So the pool deck pavers are within maybe 2.5 feet at most of the property line.
Where is the property line in that picture?
The fence. The fence in every photo is the property line. They had the fence placed right, just about right on the property line. This photo was actually taken this morning, just for reference purposes. Oops, let me get that out of there for you. And again, as you can see, same as before, it's still right within a couple of feet of the property line, which is the black fence, and the pool pavers start. Any questions?
Is the fence itself, can that be put on the?
Fences are allowed to be placed right on the property line, yes, sir. It's only the pool deck and the pool and its associated deck that is considered a structure that are required to not be built into the setbacks.
Was any indication made to you of why the variance request was withdrawn?
No, sir. And in every instance since, basically since September of last year, when Mr. Tate had told me that his contractor was going to work on getting a variance, at every indication from that point all the way up until the email from Miss Melissa Ward just recently on March 19th of this year. So from September of last year to March 19th of this year, I'm not sure. There's only one pre-app that I know of that ever happened for the variance request, and nothing further ever came of it. And I don't even know if it was an official pre-app. I believe Andy contacted Vivian Schammel with the Walton County Planning Department to request information on the variance. As far as I am to understand, there was no other formal application put in for it. Any other questions?
No, I guess not.
All right. Thank you, gentlemen.
Do you have a recommendation?
Oh, I'm sorry. Yeah, let me finish that part for you. All right, so the conclusion of law, this is a lawfully constituted code enforcement proceeding convened pursuant to Chapter 162, Part 1 of Florida statutes and Chapter 12 of the Walton County Land Development Code. The Code Board has jurisdiction over the subject matter, and the respondent. Notice of this proceeding has been duly provided to the respondent as required by county code. The respondents, Jeffrey and Terry Tate, by reason of the foregoing facts, are in violation of Chapter 5.00.03 building setback requirements of the Walton County Land Development Code. The respondents are subject to the enforcement jurisdiction of this board. It is my recommendation that the Code Enforcement Board determine, one, that the address 106 Beach Drive East, Miramar, Florida 32550 is located within the unincorporated area of Walton County and is subject to Chapter 5.00.03 of the Walton County Land Development Code. 2, the proper notice of this hearing was given to the respondents. 3, that a violation of this Walton County Land Development Code section 5.00.03 does exist. 4, the respondent is to correct the violation within 30 days of the date of this order by removing the pavers from the building setback and provide an as-built survey showing that these pavers have been removed from the setbacks. The respondent is further ordered to contact the Walton County Code Enforcement Department to arrange for a reinspection of the subject property to verify the compliance. If the respondent fails to comply with the above actions or fails to bring the property into compliance with the applicable codes, ordinances, or regulations according to this order, the board assesses a fine of $250 a day until the property is brought into compliance.
Okay, no more questions for Mr. Rose? Yes.
Something occurred to me. Would a complete privacy fence there be acceptable?
The fence doesn't make a difference at that point. It's still going to be into the setback. You can't build a house into a setback either and put a privacy fence in front of it. Setbacks are subject to whether it is or is not in behind a privacy fence. It's still into the setbacks. The fence would still be allowed, whether it's chain link, whether it's a nice iron metal looking one like this, whether it's a privacy fence, they're allowed to be on. Yeah.
Yeah, I know. I'm just saying, I'm just getting to the point.
Yeah.
It's legal to put a privacy fence there.
Correct.
Is it legal to have one a lot higher than that fence? Can it-
Sure.
This might be nitpicking, but you can put grass there, right?
Grass, where?
In the setback. You can plant the setback
Yes.
in grass. Could you plant the setback in artificial grass?
Yes, and in this particular instance, there's actually 2 areas off the pool deck that are artificial turf.
And that's permissible.
That is permissible.
Okay.
It's, in this particular instance, it is just the paver deck that is currently in the setback.
And about how many square feet of pavers are in violation of the,
I would not guesstimate. I can tell you that if it's a minimum, if it's a maximum of 3 feet away from the property line, that's a minimum of 7 feet of pavers that would have to be removed at a distance of probably some, I would guess maybe 30 to 45 feet, somewhere in there.
Did you say 7 feet have to be removed?
Yes.
7 foot by?
They're currently at maximum 3 feet away from the property line. My guesstimate is closer to 2 feet. However, I didn't go on his property to measure. It's inside a fence.
But the rule is 5 feet.
The rule is 10 feet away from the property line currently. That's what he was permitted to do by his building permit.
There's always one lot.
As far as I know, yes.
Now, you said this variance varies by the size of the lot?
No, what that is, that refers to if your lot was platted prior to 1975. Initially, the lots were supposed to be 10,000 square feet or smaller, and they were going to be narrow lots. If that was the case in that subdivision, they would allow for 5-foot setbacks on those 10,000 or square feet or less lots. His lot is not that. His lot exceeds 10,000 square feet.
How big is it?
I don't have that information off the top of my head. It was on the, hold on. I probably could tell you.
It's not like 10,001 or 10,005. That's, I mean, it looks big. Why I asked if this was 2 lots on a prior plat in Wichita.
His lot is, ooh, sorry. His lot is .327 acres. So that's roughly 14,000 square feet, something like that.
Yeah.
I don't know if maybe you guys can help me out with that one. 1330? 1330.
The beach is, I'm looking, here's Beach Drive. The
Mhm.
beach is this way or that way?
It's
Yeah,
the other side of the house.
it would be,
Looking at the beach from here.
yeah, there you go.
Okay, now are we done with Mr. Rose then?
Any other questions, gentlemen?
No. Okay, who's going to tell us about the other side?
Thank you.
May I?
Yeah, you could ask. Yeah.
Mr. Rose?
Yes.
Absolutely. Hello, Michael Henry from Dunlop and Shipman on behalf of Jeffrey Tate, the homeowner.
Your name again, what was it, sir?
Michael Henry.
Okay.
Mr. Rose, in determining where the property line was, did you locate any caps around the lot or markers?
No, sir. There's actually been a previous code case against this that I had to go out to while the surveyor was there. And the surveyor actually marked out where the fence was going to be at that time. Mr. Tate's aware that I was out there at that time with him. I had spoken to Mr. Tate about it prior to that. That's an older code case because there was another complaint about that. There was also a complaint about him placing the material in the right-of-way, the trees and all that stuff, so we knew how wide the right-of-way was there as well. And that's how we came to that determination that the fence was directly on the property line. He was allowed to leave the trees and everything in the right-of-way. There was no violations at the time, but those prior cases gave me information as to where that property line was going to be approximately.
Approximately.
And everything else from beyond that. And even if the fence was an inch or two away from that, or even 6 inches away from that, it still doesn't account for 10 feet.
Okay. But you were never out there after the fence was installed with a surveyor?
No, not yet.
For the exact location?
No.
Okay, thank you.
Nope.
All right.
Okay, Mr. Henry, you're going to speak to us?
Yes. Good evening. As I said, my name's Michael Henry. I've got a packet of some information I'd like to share with you. You still have a copy of it?
Yes.
And Mr. Rose, you have no objection to this packet being distributed to the board? No objection. Then we accept it as evidence. We'll call it Exhibit 1.
The first document depicted there is the property appraiser's aerial shot of the Tate's property. Can show Beach Drive coming around. If we're looking at this, the beach would be south of Beach Drive, below the quay. So Beach Drive borders the Tate's property to the south and also to the east. As depicted, there are no neighboring properties to the east or to the south of the Tate's property. The next picture, labeled Exhibit 1, is a picture taken showing the fence line and an area of gravel between where the pavers begin. As you can see from the picture, the pavers are on grade. They are not elevated. They are equal to the surface. The next picture, Exhibit 2, is a picture standing on Beach Drive facing to the east. It shows the area of the right-of-way of Beach Drive over to the Tate's property. You can see his fence on the left-hand side and then the pavers beyond that. The next picture, Exhibit 3, is a picture standing on the east side of Mr. Tate's property facing towards the southwest, again showing that the pavers are on grade. There's an area of gravel before the fence line. And Exhibit 4 is a picture standing on Beach Drive facing east. You see a little bit bigger picture of the right-of-way, and you can see on the south side of the road, it looks like some wooden structures, maybe some landscaping timbers that go all the way up and abut the right-of-way. Exhibit 5, the next picture is a picture of the right-of-way looking to the south, showing those landscaping timbers abutting the right-of-way. As we said, the area in question and the fence property line does not border any neighbors. There's no encroachment of any pavers that would cause any water to come off of the property onto any neighboring property. But one point that I want to bring to the board's attention is Exhibit number 6. Officer Rose talked about that this would be, that the Tates are in violation of 5.00.03 of the Walton County Land Code, Walton County Land Development Code, and an encroachment into the building setback line. Currently, 5.0007 of the Land Development Code is the methodology for determining the setback requirements. As it is right now, pool decking would be an encroachment even on grade. However, on May 10th, last week, the Planning Department unanimously approved some amendments to the Land Development Code and voted to send those to the Board of County Commissioners for a vote to approve. I've got excerpts of the proposed changes to the Land Development Code as Exhibit 6. The last page shows that the methodology for determining the setback requirements, 5.0007, it's proposed that will be stricken in its entirety. Instead, on the second page at the top, there would be a new portion of 5.0003, the code in question here, with some amended language, and I want to read that to you. 5.0003 B2 proposed language says accessory structures and buildings as defined in Chapter 6 of the Land Development Code are subject to the same setback requirements as the primary structure, including but not limited to both in-ground and above-ground swimming pools, hot tubs, and similar structures, and any decks or surrounding improvements associated with such accessory structures, except that non-elevated accessory structures such as walkways and at-grade patios or decking installed at a height of less than 6 inches from grade shall be allowed to encroach into the setback area, provided that this encroachment does not exceed 20% of the total required setback area on the lot. At-grade patios and similar structures not providing for access are prohibited within 3 feet of any lot line when utilizing this 20% allowance. Should this amendment be passed by the Board of County Commissioners, and as I represented, the Planning Department unanimously approved these changes to send to the BCC, the at-grade pavers would not be, are exempted and would be allowed to be built into the setback. So we think it may be a little bit premature to vote today if there's a violation, because there's a substantial likelihood that this amendment will come into being very soon. And therefore, if there was an adverse ruling tonight that would require Mr. Tate to remove his pavers, he may be able to put them right back in a month or two from now. So one thing that we'd be asking is for either a continuance of today's hearing, or the board considering not voting tonight and waiting to see if the BCC does approve the change to the land development code, because we think that would have a bearing on this lot.
Do you know for a fact, it says, the proposed language says
Mhm.
within 3 feet of the lot line, and
Mhm.
Mr. Gross indicated that he thought some of these pavers were within 3 feet. And it says 20% of the total required setback area.
Mhm.
Does the alleged existing violation exceed 20% of the total required setback area?
We do not believe it does, because on the other 3 sides of the property, I think it's undisputed that there's no violation, that there's no structure, no pavers, nothing built into the setback. It would just be a portion of the property to the south.
Does the county agree with that assessment? Just speak up, it'll be all right.
No, it won't, no.
Oh, that's right.
At this point in time, I couldn't make any assessment one way or the other with that. This is actually the first time we've seen the language come through. It is proposed language, and it really doesn't have any bearing as far as this case goes, as we're concerned, as this violation happened prior to this. This happened last year. So at this time, unless we were given the opportunity to go on property and actually physically calculate it, or have one of their surveyors or engineers calculate it, there's no way we'd be able to tell.
Okay.
If I could make,
Yes, Mr. Williams.
Mr. Chairman, just to point out, the methodology for the determination of the setback is not code enforcement's issue. That's determined in planning when someone comes to the planning department with submission of plans as to what they want to do. That has nothing to do with us. What we do know is there are pavers in the setback, which is why we cited what we did, okay? The whole methodology of ISR, that's all taken care of in the planning side of things. We don't make that determination, okay? So let's not get confused with what the issue is here. The issue is that there are pavers in the setbacks, period. Doesn't matter who came up with the methodology or what they thought it was. That's the bottom line.
Well, in the future, under the new rules, it looks like you might be in
And that's
percentages
correct.
rather than distances.
You're absolutely correct. However, at the time that this was constructed, it was a violation of the chapter. Now, you can make that determination. We're not, obviously, you're not a variance board. They're requesting that you do or do not make a ruling here tonight. This isn't a variance board. This is a hearing on whether this was a violation at the time it was created, which is what the county stance is.
Would you address that point?
Sure.
Why did they
Right.
never follow through with the request for the
Right.
variance?
There was a good faith belief that the lot would qualify for the 5-foot variance based on the lot being platted prior to 1975. After discussion with the county and the planning department, where they made the determination that based on the total square footage, that variance wouldn't apply. That was one of the avenues that we were thinking of asking for a variance, so we decided, given that determination, we would abandon that request. About that time is when that we requested the hearing. We also became aware that there was going to be potential amendments of Chapter 5, so kind of shifted our focus on requesting the hearing and bringing this to the attention.
It seems a little strange. You had a logical legal recourse.
Mhm.
You could have requested a variance, and then, hey, everything would have been fine. Instead, you chose to leave the intrusion in place, and instead hope that because the law may change, or the code may change, we're going to allow you to remain in violation. In good conscience, it would seem that a person should have followed through on the request for the variance.
Well, and what's being requested is the entry of an order that would require the Tates to remove a portion of the pavers to bring it in compliance. Given the state of the land code and that it may change, that's what we're saying at this point. It may not be practical to enter such an order that could be undone possibly during the 30 days to bring it in compliance.
Okay. Do you have, yeah,
And,
of compliance. Yeah.
and I apologize also, a decision not to ask for the variance was there was a certificate of completion given for the swimming pool that was done after the pavers were put down. So we believe that it was in compliance since the certificate of completion was issued for the pool.
That was issued by the building department?
Yes.
Yes. Yes.
If I can answer to that,
Yeah.
Mr. Chairman,
Yeah.
I will say that this gentleman.
Come up to the
brought
microphone,
these plans to the
please.
planning department.
He can't hear
Come
us.
up to the mic.
Yeah,
So this survey here is what was brought to the planning department.
right.
It is our belief as the county that the engineer, the gentleman who did the actual work, was aware of what the setbacks are and what was permitted. They would have been told that in the planning stage. So they submitted this and then still went outside of what they submitted to the county here based on where the pavers are currently. Even though it was CC'd, I can't speak to that. That's the building department. But this is what was submitted, and it was not what was built on site.
Mr. Henry, do you have more for us?
I would just end with, given the location of the lot, that there is not a neighboring property that there's any encroachment on, there is no issue that's created by the location of the pavers right now causing any problems on neighboring properties, and given the state of the land code and the potential change right on the horizon, I again would ask that the board choose not to vote today or suspend rendition of any order to see what the commission votes. If they strike down the potential changes and the land code stays as it is, that would give the code enforcement board direction on which way the vote should go.
And if they don't strike it down, are you just prepared to remove the encroachment?
If that's what the decision is, and the order would require him, that he would have to do so, otherwise face penalties.
Any questions for Mr. Henry? If not, I'm going to close. Yes, sir, Mr.
I have
Rogers.
a question,
Yeah, go ahead.
Mr. Henry. Mr. Henry, was your client aware of this ordinance change at the time that he made the decision to put the pavers in?
Rose.
I'm sorry. Mr. Henry, was your client aware at the time that he placed the pavers in there that this ordinance may or may not have changed?
Honestly, I do not think he would have been at that time. However, he did receive the certificate of completion for the pool, so he believed there was not an issue.
Okay.
I've got a question.
Yeah.
Yes, sir.
What was the original complaint made about?
The original complaint came in as a citizen call-in complaint that the pavers were added to the setback.
A what, from a neighbor?
Yeah. And ultimately, I mean, it's very common that happens where the neighbors call them in, so it's one of those things. And a lot of people try to get away with a lot of different setback issues that way. But ultimately, as far as we're concerned, we go out, we investigate everyone. If it's a violation, it's a violation. If it's not, it's not. In this particular instance, it was a violation at the time we went out and inspected, and it's another one of those situations where they're asking for forgiveness instead of permission.
Is this
So.
consent for or off? Scenic 98?
It's off of scenic 98, but not in the scenic corridor. It's pretty far off 98.
It's not the scenic.
Who put all the palm trees and bushes in the right of way?
Mr. Tate.
Who?
Mr. Tate or one of his contractors at the time. But yes,
No complaints about that?
yes, there was a prior complaint about that. However, the county allowed him to leave them in there.
I'm sorry?
There was a complaint to that he was encroaching into the right-of-way for that purpose of putting landscaping in, but the code allows for landscaping to be placed in the right-of-way.
If I may.
Yes.
You're maintaining that area too, but.
Yeah.
Mr. Tate is maintaining that area, mows the grass, keeps the landscaping up, and as you saw from the pictures, I don't think anybody would question that. He's doing a great job of maintaining that area.
Absolutely.
Okay.
I just wanted to make the board aware that Mr. Henry stated that there's no neighboring properties where this could be an issue. There's no language in section 50003 regarding setbacks that says anything about whether it impedes a neighboring properties or anything like that. It basically is straightforward, so.
Okay. No more questions. I'm going to close the public part of the hearing, and we'll discuss this among ourselves. My opinion is, I don't like the fact that they didn't follow through with the request for the variance. It's like instead, they are hoping that the law is going to change and that they'll be forgiven.
Well, it appears they weren't even aware that the law was going to change at the time. So they did encroach and violate what they filed.
Right.
Well, they stopped taking the variance because they got lost.
Right. It's a logical argument, but it's not a moral argument.
Let's do it then.
Yeah, but the owner had to pay the attorney's fees, and he was making, I'm just speculating, making a judgment as to whether I paid the attorney to go ahead with the variance and doing that, or just wait and see if it's reasonable. Set of circumstances to alleviate the problem in the long run anyway.
Well, they wound up paying the attorneys anyway.
Yeah.
When do they anticipate the change in this?
That's a good question. Do we, I mean, we don't.
Our discussions earlier were, Ms.
Melissa Warwood, Dunlap and Shipman. They're proposing to take the first hearing for that Chapter 5 in July. They're workshopping the part of that ordinance, not the part about this, in June, and then they'll have the second hearing, proposing to take it to the board in the second hearing in August.
So September 1st would be a logical date if everything went smoothly?
If everything goes smoothly, yes.
September?
Yeah. And this is now June, July, August, so 90 days, a little more than 90 days.
You know, this isn't hurting or keeping anybody from doing, building something else. It's not hurting anybody, and it looks pretty good to me the way it is.
It's against the law.
Yeah,
Okay,
but
we're not here.
just because the size of the lot is less than 10,000 feet, which was an arbitrary number to put.
I get it, but it is a clear violation, okay?
Would it be necessary, like I think you're suggesting, is that we pen this for 90 days, subject to,
You said something about if you were a betting man, you'd do it, okay? And look, I haven't thought this through, but what I was thinking in my head was that, well, what if we say, after 30 days, he starts paying the fine, and if in fact they change the law, then we'll forgive the.
waive the fine?
We'll waive the fine.
I think that's illogical.
Can't
Can't do that?
Well, you
I don't
possibly
want to
could,
screen
but
over here.
If we voted that time.
that sets a bad precedence, I would think, and I'm not sure, I would have to research it, but I'm not sure if that's quite legal to do it that way.
And why is that?
Well, if you're making it a forgiveness based upon something that may or may not happen in the future contingent, which if you're gonna do that, just make the order, the start of the order at the day of the contingency, not now and then refund. Because you see what I'm saying? It would be more logical to say in 90 days is when the order, compliance with the order starts, than to say, oh, we're gonna start it in 30 days, and if he doesn't remove it, his fine accrues, and we'll just forgive the fine. That's not a logical way of it.
So you would state that the fine would have to start at the end of the 90-day period?
And frankly, if you're going to go with that, the county commission may delay, and you can always you can always, he can always come back and ask for a continuance on the order, an extension on the order, which at 90 days, they should know whether or not the county can have a more deadline date.
Well, can they also go back and ask for the variance during this period of time?
I believe it
Would
can.
give them a second option rather than bring it back towards the board.
In 5.00.003, section 7 says nonconformance that doesn't give anything prior to 1975, it doesn't have a limitation on square footage. That was a director's decision in 2016 that put that, that placed that number.
Yeah.
So the ordinance, the land code itself does not give, does not state that, from what I'm reading.
Really, that was just,
That was a director's, and that's in Mr. Rose's, is that it was a director's decision, DD-2016-02, that added that language.
To this,
To that, well, no, not to this lot, to the 5.003.003 is an interpretation from the director. And I would assume director of planning, is that correct? Yeah, yeah, please.
Heather Chrisman for Walton County. The county does not have any objection to you doing essentially what council is suggesting. What we would be okay with is having an order finding a violation of the Land Development Code section does exist, giving the respondent, we're okay with the date in September to come into compliance. That way, there's some time that perhaps the VCC will change the code. If that's the case, then this issue is moot.
Can't we just table this until then?
Well, the issue with that is we've had a trial on it now, and if you table it, we're going to come back and we're going to go through this process again. The county would like for there to be an order as it stands right now. Today, there is a violation of the County Land Development Code, but we are okay with the ample time for the compliance date. I think that makes
And
sense,
if you're
and it
gonna-
avoids having to have a whole other hearing.
is the director's order part of the code?
Well, you can maybe address that a little bit.
Essentially, the director determination, those are in the file. If those aren't appealed, then those become a
So he would need to
interpretive
appeal it,
tool.
but it's, it hasn't been appealed yet, from what I know.
I think it was made in 2016, and there
so it
was,
hasn't- It'd be a case of first instance here. Now, if you're gonna do the 90 days, we'd be looking at not September 1st, but,
whatever
yeah.
day y'all choose, but I was just letting you know, the county doesn't object to that.
I think that's the most efficient thing to do.
I do too.
I doubt if the director had in mind a lot like this, when he came up with this 10,000 foot roof. So I think we can throw that out as a group and say that, it's a reasonable group of folks. This is, and especially with the likelihood that, the DCC could meet tomorrow and pass this.
yeah, but he is in violation, and I don't think we should just forget about the fact that we've had this
But if
meeting.
he'd gone and looked at the law, he wouldn't have been in violation.
Well, it may be that's why, and I can't speak to why they gave him a certificate and if it had to do with the survey or not, but they would have been there to measure too, but it could be that they were relying on this and didn't look at the DD. They just went by this. If that's what happened, then that's the reason why a certificate, it's still, according to the director's decision, is a violation because he's over 10,000 square feet. But if you give him the 90 days and the county commission meets, it's a moot point, the order goes away. So no harm, no foul. And at the end of 90 days, if the county commission has not met and has not completed this, then Mr. Henry can move to you for an extension on compliance with that order. So
So-
you can then extend it again if you need to.
If we say he's in violation today and give him 90 days before we put it into effect, and the county changes the code, then this becomes a mute issue.
But you need to put that in the order, that it's subject to the county code. The county's decision would make this order, we need to put that in the order as well.
I think that covers both sides of the fence.
Would
Yeah,
you make
I would
a
agree with
motion
that.
to
So move.
Second,
Second. I'll vote for it.
any further discussion? Okay, if not, do we need to phrase it to lead the board?
Yeah, how am I going to phrase it?
Let's hear
Yeah.
you.
Would you assist my phrasing?
I will, I'll do my best. Heather may need to help me. You're following the recommendations of the Code Enforcement Officer Rose, subject to the following changes. He is 90 days from the date of this order to be in compliance, or a $250 a day fine starts at that time. However, this order shall be subject to the Walton County Board of Commissioners changes to section 5.00.03 of the Land Development Code. If they change to where his encroachment is not, is no longer an encroachment, then this order is moot. Or
So
void.
moved.
Is void.
Who seconded it?
Yeah.
Okay. You want to discuss it?
A question occurred to me, what you were saying that, if the board delays it beyond these timeframes we're talking about, you know, what happens then?
He can come back.
He
Comes
can-
back.
If
Comes
the
back
board,
here.
that's what I just said, if Mr. Henry can then move this board for a extension of this order, a continuance of this order.
Another 90 days.
Or he could go to the board and try and get it varied.
Right.
All right, so I'm going to call for the vote. All those in favor, aye?
Aye.
And the motion carries. Okay. There's no further business. I listen to a motion for adjournment.
I move to adjourn.
Is there a second?
Second.
We are.
No, well, you can pass them down here, and then we'll include the one